to the Web3 Masterclass from CryptoVixens. Today we are honored and excited to have Mr. Todd Kulkin here from Warren Law Group in New York. We are talking about building to scale. One of the biggest problems that startups face is they have a really great idea and they go for it, and either they did something wrong and it causes them to fail, or they did something right and they skyrocket to the moon, and then they realize they have to figure out what to do with $400 million. Those are both problems we need to solve.
Yeah, they're good problems to have, but they're still problems that can pretty easily be solved with, an ounce of prevention being worth a pound of cure.
This is your ounce of prevention. So if you have a startup idea and you want to make sure that it goes far and wide and you are protected, legally compliant, with regulatory cover, and architected in order to build in that tokenomic structure that really gives value to your holders, this is the class for you. So Todd, before we get started, can you introduce yourself a little bit about your background and, aside from the fact that you're very dapper, darling, why you are the ideal person that we need to listen to?
Oh, having to sell myself? But that's what my managing partner is for. All right, I'll give it a shot, though. Greetings and salutations, everyone. I'm Todd Kulkin. I'm a partner at the Warren Law Group. I handle 5 different verticals. First is general corporate law, anything you expect from a general counsel of a major corporation. The second is securities offerings. We handle every type of private security offering there is, from Reg D, Reg crowdfunding, Reg S, all those other things that make you snore, but also make you money. Third, tax-exempt organizations. Actually, personally, and just to humble brag, I don't know if that's what the kids are calling it these days, but anyway, so I've personally helped over 250 nonprofit organizations receive and keep their 501c3 status, and I'm rather proud of that. But I do handle other types of tax-exempt organizations as well, and I mention that because in your journey of making sure you are tax minimized on both the for-profit venture side of things and the stuff you want to do to save the world, because every Web3 founder has an idea as to how the world could be made better. You want to be thinking about the tax-exempt entities. We can talk about that later if you'd like. Fourth is international commerce, my personal favorite. That has to do with the movement of assets, both liquid and illiquid, between borders. And the fifth is Web3, which is applied in all 4 of those other things. So that's me. It's a real pleasure to be here. Thank you so much for having me, Adryenn.
Oh, I'm so excited. So the big thing about Web3, first of all, we are all talking about this decentralized global economic renaissance where everything moves at the speed of light. I mean, even faster than a 10-minute block on Bitcoin. So we want seconds to finalize a transaction. We want to do cross-border. We want to do, multi-chain. Like, the future really is anything we want it to be. So when we're thinking about these things, the first question that I always ask the founders is, where are you domiciled? And they look at me and they go, well, I live in Georgia. I'm like, why does that mean you had to pick Georgia? Like, where you domicile is very important. The crypto laws in different countries some of them are good, some of them are bad. Some of them are, execution style, and some of them are really lax, but they're not really reputable. So choosing where to domicile is one of the biggest questions that every founder should ask before they even get started with their idea. Because your idea, if it's truly Web3, can literally have its seed planted in a domicile anywhere in the world, because we're all interconnected. So what are some of the things that people need to think about when it comes to where they are going to domicile?
Well, that is, as you say, the big question, right? I would take it one step farther, though, and just say, where should I domicile the different aspects of my idea? Not where do I domicile my idea? And that's a centralized way of looking at things, is it not? Which, from a corporate law perspective, is really comfortable, right? Oh yes, centralization. You do it in Delaware, you do it in Nevada, you do it in the UK, what have you. But if you think about a truly globalized world, truly decentralized way of doing business, you actually have different aspects of that idea domiciled in different places based upon what is the optimal treatment for those particular aspects. May I use the whiteboard?
Yes, please. And I was just going to say, Facebook and a lot of the other biggies, they don't pay taxes. And the reason they don't pay taxes is because they have availed themselves of a complex legal structure that literally minimizes taxes to the nth degree. And avails itself of grants and research development and zones and this and that. So are you going to whiteboard out how we should actually structure or think about, contemplate, because I do want to make sure everybody knows everybody's different, just like we're all little snowflakes. There is a general framework, but you do need to lawyer, those of you who watched me on Clubhouse. Lawyer. I am not a lawyer, I just play one on TV sometimes. Todd is an actual lawyer.
But I'm not your lawyer unless you'd like to be, in which case we do an engagement. To that point, everything that we're discussing here today is for informational purposes only, not meant to be legal advice, tax advice, or financial advice.
Yes, so that's the disclaimer. And I play a lawyer on TV sometimes, but I am not a lawyer. I'm also not your lawyer.
But unlike most people who play lawyers on TV, you actually know your shit.
Yes.
Yeah.
Yeah.
Beautiful.
Thank you. This is why we play well together.
Indeed. Speaking of which, whiteboard?
Please play.
Yeah, excellent. Okay, so the way in which...
Oh, also like a lollipop, but don't lick it so we can hear you better.
Like this?
So it's like right there.
Got it. How provocative. I love it.
It's the sweet spot.
Indeed. So this is how the world works according to, I would say, regulators and basic tax lawyers. I'm talking avocado toast, Sex in the City brunches. Is that still a thing? You know what?
It is totally still a thing.
So the basic level, okay? So you have the US and you have offshore, okay? Now, offshore seems to be this mystical land that's somewhere else, and it's all the same, right?
No, offshore is illegal. Offshore is dangerous. We can't go offshore.
My God, you sound so scared. That's...
I am supposed to be big. I'm afraid of out there. They tell me that it's dangerous.
So it's dangerous if you don't do it right. Right? Just like when you go swimming, so let's talk about going offshore, going into deep waters. Just as there are bigger creatures out there in the deep waters, and there are larger scale dangers, there's still a way to do it right. And the beautiful thing about a lot of these structures is that there are multiple ways to do it right. You need to consider just a few things before I talk to you about specific jurisdictions. I want to make sure we talk about 3 things, okay? Try not to upstage myself here. The first thing, any money laundering. I would say the most important thing. If a regulator thinks that you are laundering money yourself, or more likely if we're dealing with a Web3 project, creating a vehicle, thank you very much, for money laundering, you're done, okay?
So basically that means if you have a decentralized project, a DeFi project that allows people to put in mass sums of money, transfer mass sums of money, convert mass sums of money, and you don't know who they are or where they came from, they might get a little sketchy.
Exactly right. So we have AML, we have tax, we have intellectual property, and we have liability. I want you to think about those 4 things. Now, the other thing you also need to consider is where you physically are, right? So we'll just say where the income is, actually where it lands.
Well, where the income lands, or where my physical space is in a bikini on a beach having pina coladas?
Exactly right. So it depends entirely on where you want to access your money, where you want to access your assets. Now, let's take a super basic but extremely powerful structure, okay? Let's say that you want to, that you have a trading algorithm that you want to deploy, all right? Now, right now, and I say this specifically because these laws are always subject to change. This is not the kind of thing where if I tell you today, do this in the British Virgin Islands, that forever and always, British Virgin Islands will be perfect for this, okay? Just make that clear.
And remember, in Web3, everything changes daily, hourly, at least monthly.
So let's take one of my clients who is they're a cryptocurrency derivative company, all right? And they are, they are registered in an exchange in South Korea. And they wanted to avail themselves of, for tax purposes, for AML purposes, and also for liability purposes, want to bring in offshore money to US-related trades. So here's what we did. We put together
BVI stands for British Virgin Islands.
Thank you, appreciate that. And then here we have Grand Cayman. Okay, so we have a fund in Cayman. We have a managing entity in the BVI, And we have a feeder fund here in the US. So what does that mean? From an anti-money laundering perspective, let's pretend for a moment that we're US Treasury officers and we're trying to figure out, is this wrong? Is this a problem? Is this not compliant? So let's start with anti-money laundering. Where's the money coming from? It's coming from US citizens via financial institution, that's a Fed member, say a Fed member bank like JP Morgan Chase. Okay. They're under Regulation H. We know that if the money is coming from there and it's done via FedWire, we don't have to worry about AML in terms of the money going in. What about the money coming out? We'll get into that in a moment. So the money goes into a Grand Cayman fund that is managed by a BVI entity. That BVI entity receives a fee, however much percentage it is, and the BVI currently, there are no regulations surrounding cryptocurrencies or anything of the like, except that virtual currency is tax-free in the BVI. That's subject to change and probably will change sometime in the next 5 years. But fortunately, unlike Web3, which as we said moves out every second, the legal systems move much slower than that. We can take advantage of that.
Unless you have the fast pass, which we'll talk about later.
Fair enough. So the management entity is owned by a company in another jurisdiction, which I will not mention at this time because you don't need to know, which is ultimately owned by a holding company in the US.
I didn't see that coming.
Really?
No.
So, but the question is,
I know. Never bring it all the way back to the
right?
US.
Why would you do that? Right? Why would you want to bring the holding company? Why want to bring the money into the U.S.? Well, if you want to buy U.S. stuff, you can't avoid bringing money into the U.S. However, there are a couple of ways of doing it. One of which is just a basic dividend from a subsidiary to a parent, and there is a thing in the tax code called a qualified dividend, which allows you to take in that dividend at capital gains plus a couple of percentage points. It's pretty good for some situations, but not all. But there's another way of doing it, which is well, let's put it this way, it's not the batarang. It's like in my bat belt, it's not the batarang, it's something I use all the time. It's like the grapple gun. I use it pretty often, but not literally all the time. It's a credit facility between an affiliate and, between a parent and a subsidiary. And so long as this entity that is lending money out to this entity is making a profit, and this is the formula that I put together for this, it's cost of capital plus more than or equal to 1%. So, if, say, you were getting, you have your cost of capital here, let's say it's, $50 for every 1,000. All right, add a percentage point to that, and that's the promissory note between these two companies. Why does that matter? Because proceeds of a loan are not income for tax purposes. That's something that everyone at the IRS knows, everyone is completely comfortable with. But the thing that generates a nexus event, in other words, that can remove this entirely, all is taxable, is if and only if, which this stuff was on Web3, right? Anyway, so the way you can completely screw this up, and this unfortunately happens more often than not, is if you don't structure the credit facility correctly and you create what's called nexus, okay? Nexus is the thing you want to avoid. From a tax perspective, it means that you can consider two entities in the chain across jurisdictions to be the same thing. Now, where does that screw you up? It screws you up from a tax perspective. Obviously, we just talked about that. It also screws you up from a liability perspective. Because if these two things are considered alter egos of one another, then this entity is liable for what this one does and vice versa. And this goes back to something that I think every entrepreneur either does know or should know, which is the corporate veil. The whole point of corporate personhood is so that you are separating out your commercial life from your personal life. Your personal assets, including those assets that are being willed to your children, are separated out from the business. If you commingle these things too much in your structure, guess what? A wily plaintiff's attorney can say, oh, I'm going to go after the personal assets because there's alter ego liability. It pierces the corporate veil.
And this is why it's so important when you're designing your corporate structure and people go, oh, well, you can just use an S corporation, live out of your S corporation, pay yourself the tiniest little little bit, and then only pay taxes on that is very, very dangerous because you're literally looking at the woman who pierces. I spent 5 years piercing corporate veils in family law. I got it all. I always got it all. It's so easy when people are playing at that level and they're not doing it correctly and they haven't been trained on how to do it correctly.
Exactly right.
You cannot go buy your groceries on your corporate card because your groceries are for your house, for your personal consumption, for you and your family and your kids, and any little things like, heck, I got it on sunglasses one time. It was awesome.
Oh, I can imagine.
I literally had the whole thing. I'm like, sunglasses. Why were you going to Sunglasses Hut? Why is that at all even remotely, a car shop? Like, it just makes no sense.
Right, and so my job as a corporate attorney is to train my clients and to educate them in such a way that they act properly so someone like her goes, fuck, I got nothing.
That never happens, but,
Oh, no, right, because you've never dealt with one of my clients before.
Game on, baby.
Oh, looking forward to it.
Oh, yes.
At any rate, so let's talk about AML just for a moment. So we now have, all right, the money is coming from the United States, from a financial institution that's a Fed member. It's ultimately coming back. You can see exactly how the money was made as a management fee pursuant to a locally compliant fund. All right? You have no AML problem. Your tax problem, to the extent that there would be one, you don't create that problem unless you have nexus between these two entities. And from a liability perspective, we already talked about that. We've already talked about where the income ends, but intellectual property hasn't been talked about yet. And I wonder why that is. Well, because in this particular situation, the intellectual property is a trade secret. Okay, it's the trading algorithm. Now, in this particular instance, the client wanted the algorithm to be owned by the management company, and the management company gives a license to the fund, which is definitely a good way to do it. However, if you are dealing with patentable intellectual property, all right, and I'm talking about hard IP. Get your mind out of the gutter when I say hard IP, please. I won't be able to control myself. Anyway, so I'm not talking about trademarks. I'm not talking about these things that are soft marketing IP. For hard IP, you want to go to the Isle of Man. All right. Now, the Isle of Man isn't great from every perspective, but it's really great from an intellectual property perspective because it has what's called the patent Kevlar vest. To make it as simple as humanly possible with the time we have, if you're able to get an injunction in Isle of Man court for a patent infringement, which is much easier than it is in the US and costs a heck of a lot less than it is here, because the Isle of Man is a crown protectorate of the UK, you literally get Scotland Yard and Interpol going after your infringers.
Oh my God.
Right?
Oh my God.
But only if the IP is hard.
Oh my God.
So it's exciting. This is another tool in the bat belt, right?
Absolutely. I did not know about that one. And you guys, I'm literally like, I can take the patent bar. It's the only thing you can do without having to go to law school and get a Juris Doctorate and all that. You just have to have an engineering degree, and then you can take the patent bar. Because I should be a lawyer, but I don't really want to be a lawyer because I get to play with lawyers, and then I get to say the things that you can't say.
And you can also make real money, not lawyer money, which is kind of nice.
It's kind of nice, yes. So, okay, I have questions. Follow us. Okay. Now, I love that you said the thing about the Isle of Man with the IP, because that is my whole thing. You have the IP in a holding company that does nothing.
Except receive royalties.
All it does is receive royalties. It has one exclusive management contract with the management company. So the management company is the fiduciary that is basically the agent, kind of like the sports agent.
Right, and they can tell their investors, we are the only entity in the world that is allowed by contract to use this algorithm. Very important. Because otherwise the investor is going to say, well, what are you doing? You're using me as a test and then going everywhere else.
Exactly, right? So then we have the management company. Again, you saw me raise my eyebrow and I'm like, why would I bring it back into the United States? Because I am a huge fan of places like Belize as a cock block. Because if they want to get to anything, they have to submit 50% deposit of whatever they're asking for and hire a Belize lawyer and file in Belize. And they just don't do it.
No, and Nevis is another jurisdiction that's really a really good cock blocker, as they say.
Yes.
Yes, absolutely.
I love the cock block part. Now, we have some other options. So people, whether they're in Web3 or not, they usually, hopefully, are not trying to pull it's a decentralized autonomous organization with no legal structure that exists in the ecosphere, in the cybersphere. And that's an unchartered partnership or an unincorporated partnership.
It's a license for the regulator to fuck with you.
Yes.
That's really, and as a lawyer, I'm allowed to say that.
You are allowed to say that. Also, remember, in the United States especially, it is everyone's constitutional right to get sued for anything, for any amount of money. And so you want to make sure that if someone is going to sue you, it's going to be hard to get anything. Now, we had been talking about this concept about dividing everything, right? So owning nothing, controlling everything. That is the ideal. And I happen to be a huge proponent of irrevocable dynasty spendthrift trusts. Now, everybody hears the word irrevocable, and they get all nervous, like I've got one shot to do this, and then it's it, and then I've now lost everything, which is also why I'm a fan of not putting all your eggs in one basket. So
it's a lot like particle physics. If you just have one little thing wrong, you're out of phase for the rest of existence. But if you have it just right, you're in a much better place.
A much better place. And so when you think about, the big families, the Rothschilds and, the Rockefellers and all of them, this is not even new structure or strategy.
Not at all.
At all. It's just now like, other people are doing it. We now have so many millionaires that are doing it that now you have the mainstream media going, these people are using trusts and not paying any taxes. And I'm like, Congress made the laws,
Yeah, and there's still no insider trading prohibition for congressmen.
Exactly.
Because they would have to pass that law.
They would have to pass that law. So not only
conflict of interest, Batman.
Right. Not only that, they use things called captives. If you make $250,000 a year as a W-2, you couldn't do this, and there's other ways to do it as well, but this is the only way I know, so all the Congress people, they go in making, $10,000 a year, and they come out with $20 million, and everybody goes, wow, how'd you do that on such a tiny salary?
So I do want to and maybe this is just a lawyer in me, or maybe I just want to torture you, I'm not entirely sure. We can figure that out later.
Yeah, either way is fine.
There's one portion of that statement, the first statement that you made here, that I want to change ever so slightly. Okay. You don't want to control everything, because if you control everything, everything's under common control.
Oh, yes.
What you want is to be able to access everything on an exclusive basis. I
will change up my words, because you are absolutely entirely correct. If I control, then my trustee does not control. I control, therefore.
It unravels the whole thing. See, this is these little tiny little things.
Yes,
make a huge difference. Salt instead of sugar in a recipe drastically changes the flavor profile, right?
I love that example.
Me too.
Okay, so going back to this, hopefully you have a corporate structure. And whether you are doing whether you're doing stock options, or tokens or token allocations on a vesting schedule, there are certain things you need to do, and they are timely, right?
What's up?
So when you first are issued stock options, now, like we're saying, everything changes. We don't know when it's going to change, but it's going to change. So part of this whole thing is, if you pay now your income tax on your stock options, then later on you only have long-term capital gains, correct?
Right, you're referring to the 83B election.
Yes, the 83B election that you have to actually file within, is it 30 or 60 days?
I tell my clients 30.
30, it's a hot minute, how about that? You gotta look it up, hot minute, just like when we say fuck tons and ever-loving fuck tons of money.
Yeah. And also, and this is really where, and you may not hear a lawyer say this all the time, but this is why you need a competent CPA to work with you. And actually something I do all the time with my clients is I coordinate with their CPA, because I know just enough accounting to be dangerous, and they can be a valuable ally in this type of thing. So if your CPA already knows that you're planning on doing the 83B election, and then assigning the options that you receive to your offshore Dynasty Spendthrift Trust,
I use an
what have you.
offshore dynasty trust.
There we go. That's another way to do it too. That works in particular situations for particular things. If you have that, you're not going to have to worry about it. Your CPA is going to file it, and if they don't file it and you have a problem, you can go after their malpractice insurance.
Exactly, and this is why you also want to make sure that you have your whole team. You need to have that CPA involved.
Exactly right.
And so the reason that I like an onshore irrevocable dynasty spendthrift trust, obviously everybody's offshore idea of Cook Islands, Nevis LLC trustee, there's a whole bunch of different options.
Sure, but here's the thing. If all of the income that you're going to receive is coming from the U.S. anyway,
right,
then there's no reason to be offshore.
Well,
right? And that's why a domestic trust is helpful in a lot of situations. So if you have, say, stock options in a Delaware C Corp, right, because a good chunk of the time it's a Delaware C Corp, you know that you're going to have to pay U.S. capital gains anyway. So you might as well do the A3B election, put into a domestic trust, because you're not going to be able to get around U.S. tax regardless. You might as well just do it in a way.
It's all about mitigating. Tax avoidance is my constitutional civic patriotic duty. Tax evasion is illegal and I don't look good in orange.
That is correct.
So one of the things that I like about domestic, you have 365 years for Wyoming and Nevada. You have 1,000 years for Alaska. You can see I'm literally visually pointing on the map, which I'm geographically challenged. And you have indefinite for Delaware. However, the reason I like Nevada, aside from the fact that I'm a resident of Nevada, is we have decanting laws that other states don't have, which means if some law changes 20 years from now, if something makes this trust defective, you can literally spin up a brand new irrevocable dynasty spendthrift trust in the same spirit as the original, pour the assets from one to the other, and at the moment, there is no taxable event. In 20 years, who knows, but that's the intention, is that it does not trigger a taxable event, because they want to make sure that these things can survive, because that's part of their marketing ploy to get everybody to bring their assets to their states, right?
Exactly right.
And so one of the other things you can do with these is extraordinary dividends. And again, not a tax attorney, not a CPA, just worked with some of the best in the world. So I've heard a few things, but this is why you always want to have individual advice. So the key piece is your corporation. Remember, with these irrevocable trusts, passive income is not taxable until distribution. So it can take in extraordinary dividends, apply to the corpus of the trust. That's the nut.
Yeah. The corpus, literally the body.
The body.
Think of you as the spirit or the soul of the trust. But you're in, what do you call it? What's it called? Outer body experience? Is that what it's called?
Yeah.
Your soul separate out from your body. You send the self over to your body. It
Yeah.
belongs to you because you are the soul of that body.
Yes.
The corpus of the trust.
So the corpus of the trust. So this is fully reportable on the trust tax returns.
And it should be.
And it should be, because you're not hiding it. See, this is the best part. You are never hiding anything. You are availing yourself of the laws that are available. It's reportable on the tax return, but there's no tax due. Right?
Really, that's the trick. Like,
that's
something
the
I
trick.
tell clients all the time. You don't go through the side door. You don't go through the basement. You don't, come in from above or tunnel from underneath. You walk in the front door.
That's right.
You know the rules, you know exactly what you need to do and how you need to do it in order to get the result you want. So instead of, because really there are two other ways that people try to do it. One is they try to go in from the side door. And that doesn't really work unless a legislature gives you that power, and really only the likes of Jeff Bezos and Elon Musk are gonna have enough influence to get that specifically. And then the other way is just to not report it and just hope they never find you, which I would never recommend.
I would never.
Rather just report it, pay what little that I would actually owe as opposed to the much more I would have to owe later if I did it another way, and just live my life.
Exactly.
Wouldn't that be nice, just to live our lives?
Yes. Yeah. And we are in Miami, so it is very hot here. I just want everybody to sitting up here. I'm like, are my sweat rings showing?
I'm a New York Jewish boy, so I schwitz like a maniac. Thank you so much.
So, okay, so let's talk about crypto. So we talked about the stock options and the 83B. Now, token allocations, this is another way that people go, and they're like, well, how is the U.S. government going to know? I'm a popular girl, sorry. So how is the US government going to know? We're just going to issue these ERC20 tokens. We're going to send them out to wallets. Trust me, they know everybody's wallet based on your IP. They're tying everything together. You think that
That's literally the point of blockchain. It's a decentralized ledger. You can trace it all the way back.
Yes.
Again, literally the point of the technology that they're leveraging.
It is an unfuckwithable ledger of what actually happened, and people like me who do forensic accounting literally trace it back and go, oh, busted.
Yeah.
It's super fun.
It's kind of silly that they think they can get away with too. If it weren't for that, the crazy kid, pesky kid, I forget the Scooby-Doo reference there I'm trying to make. But.
I know, I got it. But those darn kids. Yeah, I'm one of those kids. Been doing it for a really long time. Okay, so with token allocations, and we've got these decentralized exchanges. Now, one of the things that I want to make sure everybody understands, there is a centralized exchange. That would be like your Binance and your KuCoin and your Kraken and your Coinbase. When you hold your company's tokens in any of those entities, they do not belong to you, even though they're yours and it's your company and you put them there. If anything happens, i.e. Celsius and other exchanges, where they suspend distributions, where they file for bankruptcy, every single deposit, every single token, everywhere becomes their asset for the bankruptcy court to determine what to do with it.
Right, and there's no FDIC style protection for these deposits, by the way. And a lot of people that you and I both know, jointly and separately, have lost a lot of money to this. And it's really, it's like the run on the banks in 1929 all over again, but worse.
Oh, absolutely. We're going to do a whole nother class on avoiding scams, because that's one of the things I do is track down the scammers. Super fun, but also scary to see how many people fall for these things and how many, just assume this. If they are paying you anything more than 5% per month, it's likely not sustainable. If it is 3% a day, it is a Ponzi. There is no way to do that on with the caveat that
if you're a government, you can do it.
Right.
If you're a central bank of a government, you can do that.
I know several hedge funds who do this, and they make 13% a day. They're really good. They are not sharing that. They are not telling anyone about that. They are keeping all the arbitrage money for themselves. So if you see anything like that, and if it happens to be a multi-level marketing enterprise, I guarantee you it's a Ponzi. Because it costs about $500,000 to get approved and licensed as a multi-level marketing company. So that's the very first thing you should check. But that's a whole nother class. We're just giving you that little teaser.
Always appreciate a good teaser.
We like the teasers, right? We want you coming back for more. Okay. Now, when it comes to scaling, we're talking about tokens. Let's talk tokenomics. That was a little teaser on the tokenomics. We're having a whole class on tokenomics. But let's talk about the tokenomics and how to orchestrate them. How much should the actual founders and dev team and everybody, the team, get versus the rewards? And the difference between a utility and a security is basically what I'm asking, because when tokens do certain things, because that's in expectation of profit.
Correct.
Versus when things do things because I need things.
Which is utility, yeah.
Which is utility, and I always need all the things. I like all the things.
We're humans. We, of course, love all the things.
We love all the things. Yeah. So can you give us a little rundown on security versus utility and how to design tokenomics to be appropriately attributed?
Absolutely, sure thing. So you all have probably heard of the Howey test before. Maybe you've just heard it used as a buzzword. But the Howey test is it's the one piece of case law that the SEC is still using for everything that we're talking about today. All the decentralized stuff, all of the cryptocurrencies and DAOs, etc., anything blockchain based. The analysis as to is it a security or is it not comes down to the Howey test. So, not to pretend this is law school for a moment, but we're going to give it my best shot here. So, SEC versus Howey Company, 1947. It was about orange groves. All right, and the Howie company was saying, okay, you will buy orange groves in sunny Florida, and you will enter into this contract whereby, as a landowner, you are paying this other company to harvest and process for you, and then you will make profit as the landowner. Oh, but and the SEC went, well, that's an investment contract, that's security. And they said, nah. It's not, because it's not a stock or a bond. This is what I call too clever by half, or what the SEC calls gotcha. Right? So it took it all the way up to the Supreme Court. The Supreme Court created a test where there are 4 elements. Right? So number 1, is there an investment of money or something of value? It doesn't have to be cash. It could be, in fact, I've done it with diamonds and gold, right?
It can also be done with a significant amount of time.
Correct. Second, part of a common scheme or common enterprise where you put your money in and other people put their money into this common enterprise. This thing that is generating an expectation of profit off of the efforts of someone else. That's it. Okay, so if it's generating profits based on your efforts and not the efforts of someone else, not a security. If it's not expected to generate profit at all, doesn't pass the Howey test, it's not a security. Now, that doesn't mean that someone who owns a digital asset can't ever make profit off of it in order for it not to be a security.
It's the expectation
exactly
prior to purchase.
Right, and the SEC will look at it and say, apologies. I don't know.
Finish, because then I have to be funny.
Okay, good. So the trick, to the extent that there's a trick, the SEC, Chairman Gensler, who said in a speech a few months ago that he is specifically going after all these cryptopreneurs, right? You look at the thing and say, okay, other than the expectation of maybe making a profit by selling this thing, what else do I get out of it? And if the answer is nothing, they're going to call it a security and open up an investigation. But if there is a solid utility, a thing you actually get only by virtue of owning the token, then you may have something there. Apologies for interrupting. Go ahead.
And even if the architectural design of your startup is absolutely perfect, does not pass the Howey test, it is a 1,000% utility, you could end up pulling a Munchie. 2017, SEC versus Munchie. This is basically...
that's not what happens when I get stoned? Munchies?
Yeah, that too.
Oh, okay.
So Munchie was a food app. It had a digital utility token. It was back in the ICO craze. They raised $17 million. Pretty sure it was 17, 14-ish. A lot. And everything about it was a true utility. It was very useful. It was useful in the moment. It was as useful as Filecoin. Filecoin sold out and did their ICO, but all the big money came in ahead of time, so it sold out in 17 seconds. But Munchie was really a utility. However, they spoke their way into becoming a security. They spoke in such a manner and marketed it in such a manner that the SEC said you implied an increase in value in the token and an expectation of profit, even though that was not part of the white paper. It was not part of anything. It was literally just the marketing materials, nothing in the actual documentation or anything. So you have to be careful, which is why every time I have a client, I look at their website and I'm like, oh my God, did legal approve this? Like, you can't say that sentence in that way. I'm like the grammar Nazi. I'm like, you cannot say that. You have to take out this word. Like, because the last thing that I want is for something to be super successful, like Munchie was, and then have to give all the money back.
And not only you have to give all the money back, but you also get fined on top of that, and you won't be able to avail yourself of private securities offerings because of the bad actor rule, thanks to Dodd-Frank.
And I don't look good in orange either, so I never want to put myself in that position.
So the takeaway that I give my clients whenever I discuss the Munchie case is not just that perception is reality, because it really is. I mean, the SEC's job, and it's an important job, right? They're not here for no reason or to just make people's lives miserable. They're here to protect the hard-earned income of ordinary Americans, right? The common people. There's a difference between having something to explain and something to defend. And if you inadvertently create an expectation in the public, then it's as if you meant to in the first place, which is a problem. But what I often tell my clients to do is say, hey, you have a utility token. Great, it's a utility token. Sell it like a utility. But that's not how you raise your money. The way you raise your money is by doing a private offering. Say if you want to do it with American investors, Regulation D, Rule 505 or 506. We can, discuss the specifics on another day. Maybe we'll have a whole other class on that.
We're going to have a whole other exemptions.
Right. So you do an actual securities offering that's only to accredited investors. You don't need to do your S1 or register with the SEC.
Yes, you do. You still have to register with the SEC within 15 days of taking your first dollar.
You have to file Form D with the SEC, but it is not a registered sale of securities.
Correct, but you still have to tell them about it.
Of course you do, and that's the whole point of having a securities lawyer who does that.
Right.
Yeah, fair enough.
But I think entrepreneurs need to be aware of what forms and everything, because one of the people that I literally listened to him pitch. Here's the other piece of this fun part. I'm literally listening to their pitch and I'm pulling it up on the SEC website going, that's not what this says. They're saying they're raising $3 million. Their SEC filing says $2 million. They say they're oversubscribed, and this is just for informational purposes because they are already oversubscribed. And I'm looking at it going, you raised $50,000 out of your $3 million you just said. So you can't lie in public.
Don't lie.
That's the other thing. You can't lie. You can't mistake. You as a founder, the number one thing that is your absolute requirement, know your numbers. And I mean backwards and forwards, because the minute that I sit you down in front of an investor, if you could knock it out of the park and kill it in Shark Tank, they'll write you a check. I literally just watched it happen, and then I brought her. She pitched better than any founder I've ever met. And then they gave her the money, and they said, I'll give you a double if you move to Puerto Rico. Just wait till we explain how they could not have to move to Puerto Rico and have even better benefits. LLCs are pass-through events that go up to the owning corporation. If that owning corporation happens to be a foreign corporation in a tax-free place, then I suspect, I cannot say, but I do like the diversification of every single piece of real estate being its own LLC just for the asset protection, because slip and falls happen and people do get sued. Remember, it's America, and you can be sued for anything, including perceived damages of, I don't like the color just offended me and it triggered me and it's really PTSDing me right now because that color, I can't handle that color. I came to your open house and you had the gall to have that color on the wall. I have to sue you for PTSD. And that's actually a thing, by the way. That is a thing. So LLC the heck out of every single real world asset, but those assets can be owned by a holding company that could be owned by there's a way. And if you want to know what that way is for your particular circumstance, I invite you to hook up with Todd and have that conversation privately offline, but yes, there is a way.
Way not to go over the guardrails. Respect. All right. She just showed that she's not practicing law without a license. Hooray! But yeah, for the most part, there are little subtleties here or there. If you're doing residential real estate, commercial real estate, how is that real estate generating income for whom over what period of time? There are different structures for that, but that is the base for a lot of the real estate investment related stuff. Well done.
It's a general framework, and I gave it in an educational manner. And I purposely use a funny voice so everybody knows I'm not really serious. Like sometimes when I say, and it's going to go up a gazillion %. If anybody ever thought I was being serious, no. I appreciate everybody who has been joining us on the internet watching this replay. You guys rock. If you have questions, please put them in the comments below, and we will make sure that a team member gets back to you. Until next time, I'm Adryenn Ashley, CryptoVixens. Thank you very much.